Hi, everybody. When it comes to the law of self-defense, our guest has literally written the book on it. Attorney Andrew Branca is one of the leading experts in the field of self-defense from a legal standpoint. Sir, welcome to our program, and thank you for joining us.
I'm very glad to be here, John.
As someone who's been in the martial arts since 1974, I've had 1,000 conversations about self-defense with various experts from varying degrees. What I've come to the conclusion is that most of us really don't understand what self-defense is from a legal standpoint. So please help us understand, what is self-defense?
Well, unfortunately, there's a lot of information out there on self-defense law, but most of it's bad information. There's very few good sources of information on self-defense law, and I say that even as an attorney. When I first decided to specialize in use of force law back in 1998, I had to go to the law library and do primary research to learn the law myself. In 3 years of law school, we didn't spend 3 minutes on self-defense law. So most lawyers simply don't know very much about this. And the few who do, the criminal defense attorneys, most of their experience is in bad self-defense cases, not good guy self-defense cases, which are quite different cases.
Define the difference. Good guy versus bad guy.
Well, for any claim of self-defense, there's 5 elements. We can talk about those. These elements are cumulative. They're all required. They're innocence, imminence, proportionality, avoidance, and reasonableness. For your claim of self-defense to fail, the prosecutor has to disprove any one of them, not all of them, any one of them. Think of them as links in a chain. If one link breaks, the chain is broken. Your claim of self-defense fails. In bad guy claims of self-defense, invariably there are several of those elements that are so weak they're easily destroyed by the prosecutor. So what you end up with is a lot of criminal defense attorneys who have a lot of experience arguing self-defense cases partway. They get to the second element or third element and the claim gets destroyed and it goes away, but they don't have a lot of experience arguing self-defense cases all the way through to completion.
Okay, I'm going to slow it down just for a second. One of the things you say in your book that simply blew my mind, I think it ties right in what you're saying, is that the claim of self-defense is actually a confession.
Well, you necessarily have to concede that it was you who committed the underlying act. You can't simultaneously say, it wasn't me, I was somewhere else, someone else is responsible for this, and by the way, I did it in self-defense. It's logically incoherent. So by merely making the claim of self-defense, you're saying, yes, I'm the person who used force against another guy. I'm the person who caused the injury or potentially the death, but I did it with legal justification. What that means is that if your claim of legal justification, your claim of self-defense fails, what you've given the prosecutor is essentially a confession.
That absolutely is scary as can be, and that's why I find your book so fascinating. It's both fascinating and terrifying at the same time. One of the advantages of technology, obviously with YouTube, we see all kinds of self-defense situations from security cameras. I want to run through some very simple ones that are common in the martial arts world. In many ways, they're either adages or myths, and I'd sure like you to clear them up. Number one, do I have to wait for someone to strike me first before I defend myself?
Absolutely not. You're entitled to defend yourself against an apparent imminent threat of harm. So you don't wait until the harm has been committed, or at least you're not required to. You need suffer not so much as a scratch before you can lawfully act in self-defense. What you're protecting yourself against is not the injury that you've already incurred. You're protecting yourself against an injury that's about to happen. But it has to be a reasonable perception of an imminent threat. The other person raises their fist, apparently about to strike you. You can defend yourself against that. You need not wait for the blow to land.
So in that same scenario, let's say that I have a weapon. We'll go with a non-lethal weapon, a Kubotan or my defense tool, something like that. A guy is attacking me or threatening to attack me physically with his fists, kicks, whatever he wants to do. Can I whip that weapon out? Can I use that weapon? Do I have to go through the physical stage first?
You know, one thing I'd like to state up front, just to be clear to everybody, it's my position that use of physical force should be an absolute last resort if there is no other way to secure your safety. I can tell you that the cases that I consult on, people are typically putting upfront retainers out to attorneys on the order of $25,000 to $30,000. So just be prepared. There's a high cost to pay, even if you're innocent, if you use force against another person. Having said that, on the issue, this is actually one of the most common issues that I see come up from people with expertise in martial arts, is around this concept of deadly force. Many martial arts artists seem to believe that as long as they're just using their hands or something like a Kubotan, that's inherently non-deadly force. In fact, that's not how the law defines deadly force at all. The law defines deadly force, of course, as being force that can cause death, but also force that can cause serious bodily injury. There are a lot of martial arts techniques, joint locks and so forth, that can readily cause someone serious bodily injury, but not death, that would qualify as deadly force under the law. So you have to keep that distinction in mind, because the circumstances under which you're allowed to use mere non-deadly force versus deadly force are very different.
I want to get to that because there's the multiple stages you mentioned again in your book, which I'm such a huge fan of. I had a cable TV show back in the 80s and 90s, and I had an attorney on, and I asked him, I said, I'm a world champion kickboxer. I'm a black belt expert. Let's say somebody jumps me and I defend myself. How would my background weigh into the decision, or would it at all? He said at the time that because martial arts teaches discipline and there's a sense of restraint, you don't use the martial arts unless you really have to. He said it would work in my favor. Here we are in the MMA era, and I'm not so sure that I would buy into that answer now. How would you answer that question?
I would think in most circumstances it would not work in your favor. Prosecutors love to talk about the fact that someone has martial arts training. Prosecutors are allowed to say almost anything they want in a trial. You have to keep that in mind. And a lot of the tools they bring to bear are rhetorical arguments, attempts to emotionally influence the jury. They want to make you look like a bad actor. And keep in mind, I'm largely in the gun community as opposed to martial arts community, but I'm very well aware that no one on the jury is going to be a gun guy like me if I'm ever brought to trial. No one on the jury is going to be a martial arts expert like you either. So their perceptions of what people are capable of if they've studied martial arts is from the movies and television. It's a phantasm. So the prosecutor likes to create that phantasm in the jury's mind to suggest to them that, well, really, you didn't have to use the amount of force you did because you have these pseudo-magical martial arts powers. Generally, in my experience, criminal defense attorneys try to get martial arts training experience suppressed, limited from the jury if they can all possibly do it.
It's just fantastic. That's really fascinating.
Now, I should say there are some ways in which it can help you, in the sense as if you study things like pre-attack indicators. One of the arguments you'll need to make in court is that, well, you knew you were about to be attacked because the person was clenching their fists, or they had an expression of rage, or they hunched their shoulders, or they were doing specific physical actions from which you could reasonably infer that there was an imminent threat. That kind of knowledge can be very useful, but it's very specific kinds of knowledge.
There are 3 fights in self-defense, as I'm learning now. And here I am in my 40th year, and I'm learning this stuff like a white belt from you, and I'm so grateful. Before the fight, during the fight, and after the fight. Most schools will teach a little bit about before the fight. Restraint, keep your ego in check, keep your distance, watch for pre-attack indicators, that kind of thing. They spend a lot of time on the actual fight. Kick them here, poke them here, kick them in the ding-ding, whatever. They rarely, if ever, have I heard anybody discuss after the fight, because in many ways that could be the biggest. And you alluded earlier to the $20,000 retainer just to get the ball rolling. And we see on YouTube, I follow a lot of various subscriptions on this subject, and we see fights engage, a guy defends himself, and he goes one step too far. And now it becomes he's the aggressor, and he is now facing prosecution. So talk a little bit, please, about the after fight. Of the 3 fights, the 3 sequences, the after fight, wow, that could last for decades.
Well, there's a couple dimensions to this. One is you talk about people continuing to use force beyond when they should. In theory, what that means is you could fire 4 rounds or you could throw 4 punches, and the law could say, well, the first 3 of those were fine. That was lawful self-defense. But the last one was no longer justified because the imminent threat had been neutralized by that point. How this tends to work out in real life is not that someone fires 4 fast shots or throws 4 fast punches and they get jammed up with that argument. Where people tend to get into trouble is when there's a pause in the action, and 2 things happen during that pause. 1, the threat has in fact been neutralized. And 2, a reasonable defender would have seen that the threat was neutralized, and then they use force again. So the fight appears to be over, and then they re-engage when there's no longer an imminent threat. And there the law will say, yes, that secondary use of force, not legally justified, even if the first use of force was.
And another great point that you lead in your book is that it is so difficult to be able to convey the energy, atmosphere, emotion of the moment 18 months later in the cold, sterile environment of a courtroom. It may seem obvious to you during the attack, this guy wasn't finished or whatever it was. It's truly the heat of the moment. This reminds me of the movie Sully starring Tom Hanks. Sully was the pilot that took the passenger jet into the Hudson River, and years later, on trial, his career on the line, the challenge was to convey to the jury the actual human emotion of the moment, that he was not a machine. He was reacting as a human. His defense was that the computer algorithms did not take into account human thought process. It's time to react as a human being. And again, going back to the cold, sterile environment of a courtroom, that's very hard to convey.
Well, typically what we would try to do is bring in a use of force expert to testify about those dynamics of a fight. But this brings up another important issue. Some people seem to think that you can bring in an expert witness into a courtroom on a whim. You can't. You have to have an evidentiary foundation. First of all, the evidence has to be relevant. Second of all, the defender must himself have known that information when they acted in self-defense. They can't simply have learned about it later, which means from a martial arts perspective, you need to be prepared to document your training so you can make that offer of proof in court that yes, this information is relevant because it informed my decision-making when I was acting in self-defense because I knew it at the time. If you can't make that offer of proof, the prosecution is going to try to get that evidence restricted from the courtroom, and the jury will never hear it.
Can that lead back to the martial arts instructor of that student?
Oh, absolutely.
Oh,
for sure.
Please expand on that, sir.
Well, the martial arts instructor would typically be the one person you would most like to bring to the stand. They're the person who taught you. They're the person who has that specific expertise. They can speak in details and specifics about the techniques that you were taught. A third party who wasn't involved in the instruction can, of course, speak to these same things more generally, but not in the kind of detail an instructor can bring, which, by the way, would behoove people to get instruction from instructors who can look good in a courtroom. You want people who, because remember, that expert witness represents you. If he comes across as a kook to the jury, that's not going to help your defense.
That is really interesting. So let me flip that over. Rather than him coming to your defense, is there a scenario, and there's always a scenario, but that the student could say, this guy taught me to make sure that I take the guy down and I really finish him off. In fact, if you watch MMA fights, I don't know if you do, but it is part of the rules, and it's commonplace for once someone is knocked down or even knocked out, they leap on the guy and continue to smash his face or her face. It's, to me, disgusting. But it is going way past the point of no return. And if that kind of training translates into a real street encounter, could the instructor face some liability because of what he taught the student who did the smashing in the street, so to say?
Well, it's unimaginable to me he would face any criminal liability unless he was actually there at the scene advocating the physical act that you're talking about. If it was just from a training perspective, I don't see any criminal liability at all. Could he potentially face some civil liability? Sure, he could. It's America. Anybody can sue anybody for anything. If the person that was harmed was killed and their family wants to bring a wrongful death suit, or they were injured and now they have injuries that have to be paid for, certainly, if you're an instructor, you face prospective liability there.
So then what do instructors have to really teach about, going back to the third fight, after the encounter, when to stop the encounter, what is a real threat? I know we kind of ran through the 5 elements early. If we could go through them again and apply it to a martial arts self-defense lesson. So I'm in front of my class. I start out the first 10 minutes of class with self-defense. We do defense against a headlock. We do an ATM scenario maybe where someone is kind of playing like they're at the ATM and guys come up behind and I might just ask for directions, or I might try and rob the person, or I might try and sell them some stolen goods, forcing kind of a thought process, decisive thinking on the spot. So all this kind of stuff goes in. What has always been missing is, again, that third fight. So,
well, I would think to put yourself in the best position from a legal liability perspective, you'd want to make certain that you provided your students with at least the opportunity to understand the legal dynamics of use of force, so that their use of force, that they've been instructed on what the lawful boundaries are. If you do that, and then they go beyond those lawful boundaries, that's on them. But if you've never provided that kind of contextual training, then it would be very easy for a plaintiff's attorney to argue that you failed in a duty. You're teaching people how to use force, but you're not teaching them how to do it lawfully.
Guilty in many cases.
I mean, we do, as you know, we do full day classes on self-defense law all over the country. We do quite a few of them at martial arts schools just for that purpose.
I look forward to seeing your Milton, Florida seminar coming up here soon. So let's go through the 5 elements again, if you could, and apply them in the context we're describing it as a martial arts defending themselves.
Sure. So the first element is innocence. It essentially means you must not have been the first person to use or threaten to use unlawful force. Obviously, you can't have been the aggressor in the fight. If you're the aggressor in the fight, you can't claim self-defense. Seems self-evident. Where people get into trouble is that they have to remember that nobody who's judging the conduct afterwards was there at the time. Nobody knows what really happened. People only know what the evidence suggests happened. And if there's evidence that could suggest that you were the aggressor, then you could lose on that element of innocence. If you lose innocence, you lose self-defense. And that's easier to happen than you might think. Say you had to defend yourself against somebody who had a couple friends with them, and you win that physical fight, the cops show up, and the friends say, no, he started it. Well, that's evidence that you were the aggressor in the fight. It could be BS, but it's still evidence.
It's more witnesses than you have.
Right.
So I'm thinking about an example where a guy gets into maybe a push, shove, yell. He leaves and then comes back and re-engages. So he's lost his innocence at that point.
He has. He's become the aggressor in a second fight when he returns to the scene in that way. So, yeah, for Pete's sake, if you have the opportunity to separate yourself from the threat, please stay separated from the threat. If you go back, you not only can't claim self-defense, you've become the aggressor, and the other party can claim self-defense against your unlawful use of force.
Okay, so innocence is the first element. Number 2?
Imminence. The threat you're defending yourself has to be about to happen right now. So if someone threatens to hurt you later, they're going to go home and get a weapon and come back and cause you some injury. You can't use force against them at that moment. You'd have to wait for them to actually come back, or be even smarter and don't wait. Vacate the area yourself so you're not there when they come back. So you can't defend yourself against a future threat. You also can't defend yourself against a past threat. Someone comes up and shoves you and then walks away, so the fight's obviously over, and you decide, well, I'm not going to take that, and you pursue them. Well, that fight was over. That's vengeance now. That's not self-defense anymore. The third element is proportionality. Proportionality simply means that your use of force has to be no greater than necessary to defend yourself. Generally speaking, if you're threatened with only non-deadly force, you can only use non-deadly force in self-defense. If you're threatened with deadly force, you can use deadly force in self-defense.
But let's pause there for a second. That raises a lot of big questions. Kind of going back to my first one, where I might have a non-lethal weapon, do I have to engage first without the weapon and then pull it out? So if I'm attacked with a gun, let's say it comes at me with his fist and I've got a gun. Can I pull it out and wave it at him? Can I just shoot him? Do I have to expand on what you just said, non-lethal versus lethal? It's a big difference.
This will sound odd to people with martial arts expertise, but in the eyes of the law, a single thrown punch is almost never going to be accepted as a deadly force threat, unless there's some aggravating circumstance like a great disparity in size, a man punching a woman, or someone who has demonstrable, obvious, exceptional fighting ability. But normally, from the court's perspective, guys get into fistfights all the time, and 99% of the time, nobody dies as a result. So unless there's something exceptional about the circumstances, pulling out a gun to defend against the fist is never going to be found to be justified, absent some aggravating circumstance. In fact, one of the biggest problems that I see in the cases I deal with, is people go out, they get a concealed carry permit, they get a gun, they put the gun on, and that is their only defensive ability they have. Then they get frightened by some non-deadly threat of force, and they go to the gun because they panic and they're genuinely scared, and the gun's all they have, and they get charged with aggravated assault, and then they end up paying somebody like me a lot of money. The fourth element is avoidance. Avoidance has to do with whether or not there's a legal duty to retreat if you can safely do so before you use force in self-defense. This is often thought of in terms of stand your ground laws. Stand your ground states don't require a legal duty to retreat. Some people, especially journalists, would suggest that stand your ground is some aberrant law that only weird states like Florida have. In fact, it's the dominant position in the U.S. 35 states in the U.S. are stand your ground states. There's no legal duty to retreat before you can use force in self-defense. That includes states you might not expect, like California, for example. Of course,
I was shocked when I read that.
Yeah, in states that impose a legal duty to retreat, if you fail to take advantage of a safe avenue of retreat when you could have, you lose self-defense as a matter of law. So it can be very decisive.
I can imagine that is very difficult to try and create or recreate, because again, going back to that period of time for someone to make a decision under massive stress in a deadly force situation, or non-deadly force, just a real self-defense situation, but a scary situation, that's hard to replicate months later inside of a courtroom. And if the charges are strong enough, you're going to spend that time in a jail cell in many cases while you're putting together your defense, correct?
It's quite possible, especially if the result has been someone's death. It's very likely that you might not get bail at all, or the bail will be so high that it's simply not affordable.
Unbelievable. So the final one
is reasonableness. Reasonableness can be thought of as an umbrella element that sits over all the others. Everything you do, all your perceptions, your decisions, your actions, have to have been those of a reasonable and prudent person, meaning both that you had a subjective, genuine belief in the need to act in self-defense, but also that a hypothetical, objective, reasonable, and prudent person in the same circumstance would also have had that belief. You need both of those elements, the subjective and the objective reasonableness. If you fail on that, you fail on reasonableness, and self-defense goes away.
Boy, jury selection is huge there, I imagine.
Jury selection is very scary. Lawyers, we don't actually get to select juries. The phrase itself is very misleading. We have a modest capability of deselecting jurors. So a juror comes up, and we might be able to exclude that juror. But when we decide to exclude a juror, we have no idea who the next juror candidate is. So the next person could be even worse.
That's a great distinction. We have a new non-lethal weapon. It's called My Defense Tool, and there's a study that shows that non-lethal self-defense tool, the market is exploding. But what's interesting, it's selling well. But on Facebook, the most common comment is, I'll just use my Glock. I'd rather use a gun. There's a cavalier attitude towards true deadly force that could change your life forever, not to mention kill somebody, but change your life forever by making an uneducated decision. Yet most, at least here in Florida, carrying concealed classes last just a few hours. You shoot a piece of paper once or twice, you get a little card, and you're in. So that level of education is really important. Obviously, you're leading that case.
Sure. I mean, all my work really is, 80% of my work is educating people beforehand. Only about 20% of my work is actually consulting on cases, because educating people beforehand is easy and cheap. Doing legal defense at a trial is complicated and expensive. So typically we charge, I think early registration for my classes is $150. If I'm actually consulting on your case, the minimum is more like $5,000. So it's a big difference.
Let's talk about the seminars then. What's going to happen during the day? I look forward to attending these classes and encouraging my colleagues to do as well. What goes on at a full day Law of Self-Defense seminar?
So we have two classes. We have our core level 1 classes. There we go through in detail these 5 elements of a claim of self-defense. And all these classes are state specific. So if you attend our class in Florida, all of these will be illustrated with Florida statutes, jury instructions, and court decisions. We don't spend a lot of time going into the legalese. I just show it to you so you know that what I'm telling you is the actual law in Florida. And then we provide you with access to the full text of all those laws in case you'd like to read them yourself, which we strongly encourage people to do. We also talk about things like defense of property. We talk about things like defense of others, strangers, family, for example. We talk about interacting with the police in the aftermath of a use of force event. We talk about a lot of the practical legal dynamics that happen around these cases that people don't really understand unless it's been explained to them, like the fact that a claim of self-defense is essentially a confession to the underlying act. So that's about a 6-hour class. Then typically we'll also have a simulator module. We have a very high-end TI outdoors shooting simulator where we'll run people through the simulator, and then they have to solve whatever the video problem is using an IR pistol. And then they have to turn to the class and they have to tell us what they saw, what they did, and why they did it, what their legal rationale was for the use of force. And it is amazing. Of course, it's a completely artificial environment. There is no possibility of injury, but people's heart rate goes up, their breathing goes up. The stress they experience is unbelievable. And it turns out they can't remember what they saw. They can't remember what they did. And if you can't remember what you did, it's very difficult to articulate a legal rationale. Now, we do the simulator not to embarrass people, but as part of the learning experience to demonstrate to them how difficult this can be under even moderate amounts of stress, and therefore the need to be really proficient at being able to do this before a real-life event actually happens.
That sounds incredible. It sounds exciting. I look forward to it. And thank you so much, sir, for taking the time out to educate the martial arts world on the law of self-defense. Thanks so much.
Great. Glad to be here. Bye-bye.